The courtroom was already full when I walked in. Not loud, not chaotic, just that low, tight silence that makes every step sound louder than it should. Shoes on tile, papers shifting, someone clearing their throat a little too often. I took my seat at the long table without looking around too much. I didn't need to. I could feel her before I saw her. My sister Victoria sat 2 rows ahead of me, perfectly straight shoulders, back hands folded like this was a board meeting she'd chaired 100 times before. Her hair was smooth, her jacket tailored, her posture relaxed in the way only people who believe they're winning ever relax. Next to her was her husband Daniel, nodding along to something their attorney was whispering like this was already settled. Victoria turned just enough to catch my eye. She smiled, not a friendly smile, not even a smug one. It was smaller than that, controlled, private, the kind of smile you give when you think the rules only apply to other people. She leaned back in her chair, crossed one leg over the other, and waited. When the bailiff called the room to order, everyone stood. I stood too slow and steady, hands relaxed at my sides. The judge hadn't entered yet, but Victoria didn't bother hiding her confidence. She glanced over her shoulder again this time, long enough to make sure I saw it. Then she leaned toward me just enough that no one else would hear. "You'll never touch my money again." She said it calmly, not angry, not emotional, like she was stating a fact everyone else in the room already understood. Daniel nodded without even looking at me like he was agreeing with the weather report. I didn't respond. I didn't need to. I rested my hand on the folder in front of me, a plain manila folder, no label, no markings. Inside it was a sealed white envelope, thin, ordinary, the kind of thing people underestimate because it doesn't look like much. Victoria noticed where my hand was. Her smile tightened for half a second, then relaxed again. Whatever was in that envelope, she had already decided it didn't matter. That was fine with me. The judge entered. Everyone stood again. The room shifted into that formal stillness people mistake for respect. Once we were seated, the hearing began like most of them do, procedural, polite, and just boring enough to lull people into saying too much. Victoria's attorney stood first. Confident voice, clean suit, the kind of man who bills by the hour and never misses a meal. He talked about the family trust as if it were a gift, a responsibility, a burden my sister had generously carried alone for years. He explained how she had managed the assets carefully, how everything had been done by the book, and how my request for an independent review was unnecessary, disruptive, and rooted in resentment. Then he turned slightly and gestured in my direction. "My client's sister has no background in finance," he said. "She has never contributed to the growth of these assets. She chose a different path. An honorable one perhaps, but not a relevant one." Victoria didn't look at me this time. She didn't need to. The message was meant for the room. I kept my eyes on the table. The judge listened without interrupting, pen moving slowly across her notepad. No reaction, no expression. People always think that's a good sign. Victoria's attorney continued, warming up now. "This trust has been profitable, transparent, and well managed for years. There is no evidence of wrongdoing, and certainly no justification for turning a private family matter into a public dispute." He paused, then added almost casually, "This is simply a case of entitlement." Victoria smiled again, wider this time. I could feel it in my chest. Not anger exactly, not fear either. More like pressure. The kind you get right before a long briefing, when you know you'll be asked a question, and you already know the answer better than the person asking it. My attorney stood next. He didn't rush. He didn't argue. He didn't raise his voice or shake his head or pretend to be outraged on my behalf. He just placed the folder on the table in front of him and slid it forward. "Your Honor," he said, "my client is not here to argue about feelings or family history. She's here to request the court review new information relevant to the administration of the trust." Victoria shifted in her chair. "Barely." My attorney opened the folder, removed the sealed envelope, and held it out. "This document," he continued, "was submitted under advisement and verified through appropriate channels." The judge looked up for the first time and reached for the envelope. Victoria leaned back again, still calm, still sure. The judge broke the seal and unfolded the letter. She scanned the first page, then the second. Her eyes slowed. The pen in her hand stopped moving. The room stayed quiet. Then something changed. Not dramatically, not all at once. Just a slight shift in her expression, a pause that lasted half a second longer than it should have. She looked up at the attorneys, then back down at the letter, and then she smiled. It wasn't loud, it wasn't theatrical, it was small and contained like she had just confirmed something she already suspected. "Oh," she said quietly. "This is interesting." Victoria's smile disappeared. Daniel straightened in his chair, his nod turning into a frown. The judge continued reading her expression unreadable again, except now, there was something else underneath it. Focus, precision, the kind of attention that makes people nervous without knowing why. Victoria glanced at her attorney expecting reassurance. He didn't look back at her right away. His eyes were fixed on the envelope. I kept my hand on the table, steady, still. The judge set the letter down, folded her hands, and looked directly at Victoria. At that moment, for the first time that morning, my sister didn't look confident. She looked alert, and for someone like her, that was already a problem. I watched her fingers tighten around the edge of the table just for a moment before she caught herself. Victoria hated losing control in public. She always had. Even as kids, she never raised her voice. She didn't need to. Silence was her weapon long before it became mine. That small movement pulled me backward, not in memory, but in recognition. I'd seen that grip before. At dinner tables, in parking lots, in rooms where no one else noticed the shift because no one else was looking for it. Growing up, people assumed Victoria and I were close. Two daughters close in age, raised under the same roof. That assumption saved her a lot of effort. She let everyone believe it. The truth was simpler. Victoria learned early that being first meant being safe. First to speak. First to decide. First to be believed. I learned something else. I learned how to wait. Our parents liked to tell a story about us at parties. Victoria was the planner, the responsible one. I was the adventurous one, the one who needed structure. They laughed when they said it like it was charming. It never felt charming to me. When Victoria got into business school, our mother cried. When I told them I was enlisting, my father nodded once and said, "If that's what you want, no tears, no speeches." Just a quiet acceptance that sounded a lot like disappointment. Victoria didn't say much that night. She just asked if I understood how much money I was walking away from. I told her I understood exactly what I was walking toward. She smiled the same way she had in court that morning. Over the years, the distance between us became normal. She stayed close to home-built connections, learned the language of contracts and returns. I learned how to follow orders, how to read a room, how to keep my mouth shut when the stakes were higher than my pride. We talked on holidays, texted on birthdays, surface-level contact that looked healthy from the outside. Victoria liked it that way. It made everything cleaner. When our parents died 3 years apart, the grief brought us into the same room again. Not closer, just closer in proximity. The trust had already been set up by then. Estate attorneys, accountants, a structure that made sense on paper. Victoria was named trustee. No one asked if I had a problem with that. I didn't offer one. At the time, it didn't matter. I had my career, my own income, my own sense of order. The trust was something abstract, like a savings account you forget exists because you don't need it. Victoria handled the paperwork with practiced ease. She spoke in numbers and timelines in phrases like long-term strategy and risk management. I listened. I nodded. I signed where I was told. That became our pattern. The first time I asked for a detailed report, it was casual. A quick email, nothing confrontational. I needed some documentation for a routine financial review tied to my clearance. She replied 3 days later with a short message saying she'd get to it. She didn't. The second time she called, instead of writing back, her voice was calm, almost patient. "You don't need all that," she said. "It's complicated and it's being handled." I told her I just needed copies. She sighed like I was asking her to explain calculus to a child. "Trust me," she said. "This is what I do." That word trust hung there longer than she expected. After that, the delays became patterns, partial statements, summaries instead of documents, explanations without evidence. Every request turned into a reminder of how busy she was, how demanding the responsibility had become. At one point, she asked why I suddenly cared. I told her I always had. She laughed, a soft, dismissive sound. "No," she said, "you didn't. You just think you should now." That was the first time she made it clear that the trust wasn't ours anymore. It was hers. I was just someone she had to manage. I didn't argue, I didn't push. I let the silence stretch until she filled it with assumptions. She always did. From her perspective, I was predictable. The sister who went away, followed rules, didn't understand money. The one who would eventually get bored or distracted and stop asking questions. That belief gave her confidence. Confidence makes people sloppy. By the time the next year rolled around, my access had narrowed further. Statements arrived later. Some didn't arrive at all. When I asked about specific line items, she redirected the conversation toward family harmony, toward how hard the past few years had been, toward how I should focus on my career and let her handle the rest. Daniel backed her up. Not aggressively, just enough to signal unity. He played his role, well-supportive husband, silent partner, the reasonable one in the room. I saw it for what it was, a closed circle. At a family gathering that summer, Victoria pulled me aside near the kitchen, away from the others. She spoke quietly, smiling for anyone who happened to glance our way. "You keep digging," she said, "and people start asking why." I asked who those people were. She shrugged. "People who don't need to be involved." Her hand rested lightly on my arm as she said it. Not a threat, not exactly. More like a reminder that she knew where pressure points existed. That night, lying in a guest room I hadn't slept in since college, I stared at the ceiling and counted the small cracks in the paint. It wasn't anger that kept me awake. It was clarity. Victoria didn't see me as family. She saw me as a variable, and variables in her world were meant to be controlled. The realization settled in quietly without drama. It didn't change how I spoke to her the next morning. It didn't change my tone or my posture. What it changed was internal. A line I hadn't known was still flexible went rigid. I stopped asking her for answers. I started looking for them myself. When the judge cleared her throat and shifted the letter on the bench, the sound snapped me back to the present. Victoria straightened again, resetting her posture like muscle memory kicking in. I watched her carefully now, not as a sister, but as someone who had built an entire identity around being untouchable. She had always assumed I wouldn't push back. She was right about one thing: I wasn't going to push. I was going to move sideways. The judge's pen tapped once against the bench, a quiet sound that cut through the room. Victoria noticed it too. She adjusted the cuff of her jacket, the same small reset she used whenever something felt off. I kept my eyes forward. Let her wonder. The trust had been designed to be simple. That was the selling point the estate attorney used when our parents signed it. Clear structure, clean rules, assets held, income distributed, decisions documented. Nothing exotic, nothing risky. On paper, it was the kind of arrangement people brag about for being low drama. In practice, it was a locked door. The first lock was access. Statements that used to arrive quarterly became summaries. Summaries became bullet points. Bullet points became verbal assurances. Whenever I asked for specifics, Victoria responded with explanations instead of documents. She spoke fast, confidently, and always just technical enough to make questions feel embarrassing. You don't really need to see all that, she'd say. It's back-end stuff. Back-end. A word people use when they want you to stop looking. The second lock was time. Replies came later, calls went to voicemail. When she did answer, she framed everything as urgent on her end and optional on mine. Meetings were scheduled and rescheduled until the window closed on whatever I'd been trying to verify. I noticed the pattern because patterns are hard to miss when you're trained to look for them. Delays weren't random. They clustered around the same subjects: property sales, management fees, intercompany transfers that were brushed off as temporary. The third lock was language. Victoria stopped saying our parents' trust and started saying the trust. Ownership blurred into administration. Responsibility blurred into authority. By the time I realized what she was doing, she'd already positioned herself as the only adult in the room. I wasn't offended. I was curious. The moment it shifted from annoyance to concern came during a routine review tied to my clearance. Nothing dramatic, no investigation, just paperwork. I needed to list any assets or expected income that could create conflicts or raise questions. Standard procedure. I requested a full statement again. This time, I put the request in writing and included the reason: professional, neutral, clean. Victoria called me within an hour. "Why are you dragging the military into this?" she asked. I told her I wasn't. I told her it was a formality. She exhaled slowly, like she was calming herself down for my benefit. "You're overthinking this," she said. "You always do." I asked for the documents again. She didn't say no. She said she'd send them. What she sent wasn't a full statement. It was a condensed report, with totals, rounded dates missing, and categories lumped together in a way that made tracing anything nearly impossible. It wasn't wrong enough to accuse. It was wrong enough to notice. I printed it, spread it out on the table in my apartment. No rush, no assumptions, just observation. The numbers were clean on the surface. Profits up, expenses reasonable, distributions accounted for. But the timing felt off. Income appeared before sales. Fees appeared after transfers. Assets moved between entities without clear explanations. I wasn't looking for fraud. I was looking for consistency. I pulled public records, property databases, corporate filings, things anyone could access if they took the time. I wasn't breaking rules. I wasn't crossing lines. I was comparing what the trust said it owned with what those records showed. They didn't line up. One property listed as sold still appeared under a different LLC. A management company named in the trust report had no visible employees. Transfers labeled temporary cycled through the same accounts in predictable intervals. It wasn't chaos. It was organized. That's what made it unsettling. I called Victoria again. This time, I asked about a single property. Just one. I didn't accuse. I didn't list discrepancies. I asked where the sale proceeds were reflected. She paused. Not long, just long enough. That one's complicated, she said. It's part of a broader strategy. I asked if she could explain the strategy. She laughed softly. You wouldn't get it, she said. No offense. There it was, not irritation, not defensiveness, dismissal. I didn't respond right away. Silence has a way of making people uncomfortable when they're used to controlling the conversation. She filled it quickly. Look, she continued, you chose your path. I chose mine. This is mine. Mine. That word landed differently than she intended. After that call, my access narrowed again. The next report arrived later than usual. A section that had been there before was gone. When I asked about it, she said it had been consolidated elsewhere. Where exactly she didn't specify. At a family dinner a few weeks later, Daniel made a joke about me auditing the family. Everyone laughed. Victoria smiled at her plate. The joke worked because it framed my questions as paranoia. Instead of due diligence, I smiled too. I knew then that the trust wasn't just a financial tool anymore. It was leverage, a way to keep me in a position she could define. As long as I needed answers from her, she had the upper hand. So I changed the equation. I stopped asking for explanations. I stopped flagging discrepancies. I stopped reacting. Instead, I requested copies of documents under the terms of the trust itself. Formal requests, specific sections cited, no commentary, no emotion, just process. Victoria didn't like that. She responded with a warning disguised as concern. You're making this bigger than it needs to be, she said. These things have consequences. I told her I understood. I did. The consequence she hadn't considered was that the more she tightened access, the clearer it became that she was hiding behind the structure instead of operating within it. Trusts are powerful, but they're not opaque. They rely on compliance, on records, on rules that don't bend just because someone feels entitled. By the time the judge glanced down at the letter again, her expression neutral, but attentive, I had already mapped the edges of the box my sister thought she'd sealed. Victoria shifted in her seat, sensing movement she couldn't see. She had locked me out of the trust. What she hadn't realized was that she'd also locked herself in. The judge turned a page, the paper making a dry sound that carried farther than it should have. Victoria sat straighter. Daniel leaned in, whispering something I couldn't hear. I focused on my breathing, in through the nose, out through the mouth, the same rhythm I used during inspections when details mattered more than reactions. The paperwork that started all of this hadn't felt dramatic at the time. It was routine, the kind of administrative task that lives at the edge of your attention until someone reminds you it exists. My clearance review came up on schedule, a reminder that even boring accuracy matters when you wear a uniform. List assets, disclose income, confirm there are no conflicts, sign and submit. I didn't think of the trust as a problem then. I thought of it as something I needed to document correctly. The problem revealed itself in the margins. The condensed report Victoria sent didn't just omit details, it rearranged them. Dates drifted, categories merged. Figures rounded in ways that smoothed out edges that shouldn't have been smooth. It was the kind of thing you only notice if you've spent years reading numbers that can't afford to lie. In the military, budgets don't get poetic. They don't get vague. They get reconciled. When something doesn't reconcile, you don't panic. You flag it. I flagged it. I made a simple list. Asset, date, amount, source, destination. I didn't fill in conclusions. I filled in blanks. Then I went looking for the blanks that stayed blank. Public records are honest in a boring way. Property databases don't care about family dynamics. Corporate filings don't worry about awkward conversations. They show what was filed when it was filed and who signed it. I pulled records for one property, then another, then a third. Same pattern, sold on paper, held elsewhere in practice. Proceeds accounted for in aggregate not traceable to individual transactions. That's when I saw the loop. Money left the trust touched an outside entity, then came back labeled as something else. Management fees, reimbursements, short-term allocations. The language changed, but the movement didn't. I didn't need to know why yet. I needed to know whether it was consistent. It was. I printed the records and laid them out on my kitchen table, aligning them by date. I didn't rush. I didn't jump to conclusions. I checked addresses. I checked incorporation dates. I checked the names on the filings. One name appeared more than it should have. Daniel, not as an owner, not as a beneficiary, as an authorized signer, quiet, secondary, present enough to matter. I called Victoria again. This time I didn't ask about strategy. I asked about authorization. Daniel signed some things, she said. That's normal. I asked which things. She paused. Operational stuff, she said. You're reading too much into it. I asked if he had authority under the trust to do that. Her voice tightened just a bit. Why are you asking questions like that? Because questions like that tell you where the floor creaks. I didn't push. I didn't explain. I thanked her for her time and hung up. The silence afterward wasn't heavy. It was clarifying. That night I sat at my desk and opened a blank document. No headings, no commentary. Just dates, amounts, and sources. I added citations for everything. URLs, filing numbers, page references. The way you do when you know someone else may eventually read it and you want them to reach the same conclusions without you standing there. As I worked, I kept my military role separate in my mind. This wasn't an investigation. It wasn't a mission. It was due diligence. Personal, legal, quiet. The red flag wasn't the amount of money. It wasn't even the movement. It was the intent to obscure. If this had been sloppy, I could have chalked it up to mismanagement. If it had been aggressive, I would have seen risk-taking. What I saw instead was restraint, care, a system designed not to draw attention. People who do that are usually protecting something. The next morning, I requested a specific document under the trust's disclosure provisions. Narrow, justified. Hard to deny without explanation. Victoria didn't respond. 2 days later, Daniel called me. He'd never called me directly before. He asked how I was doing, asked about my work, mentioned the weather where I was stationed like he'd looked it up. Then he shifted. You know Vic's under a lot of pressure, he said. She's just trying to keep everything running smoothly. I told him I understood pressure. She worries you don't trust her, he continued. That hurts. I asked him if he was authorized to speak on behalf of the trust. He laughed, not kindly. Let's not make this formal, he said. That was the moment I stopped thinking of this as a family issue. Formal is what you avoid when the structure doesn't protect you anymore. I told him my request was in writing and I'd wait for a written response. He didn't argue. He didn't agree. He said he'd talk to Victoria and ended the call. 3 days passed. No response. On the 4th day, I received a partial document. Redacted, incomplete. The kind of compliance that satisfies no one and signals panic to people who recognize it. I added it to the file. By then, the pattern was unmistakable. Funds cycled through entities that existed solely to receive them. Fees charged without clear services rendered. Assets held under overlapping control. Nothing screamed criminal on its own. Together, it suggested something else. I consulted a civilian attorney, not a favor, a consultation. I paid for the hour and brought only public records. I didn't mention my sister. I didn't mention the trust. I described a hypothetical structure and asked where the risks were. He listened. He asked questions. He didn't interrupt. When I finished, he leaned back and said, "This stops being hypothetical if there's tax exposure." I asked what created that. Movement across state lines, he said. Mischaracterized income, concealment. I thanked him and left. Back in the courtroom, the judge set the letter down again, her eyes steady now. Victoria glanced at Daniel, who shook his head slightly, as if to say he didn't know either. I folded my hands. The red flag hadn't been a single transaction or a missing line item. It had been the decision to make understanding difficult. People do that when the truth doesn't survive daylight. I didn't need daylight yet. I needed precision, and I had it. Victoria's attorney cleared his throat, a soft sound that carried more weight than he intended. I noticed it because I notice those things now. Small signals, micro adjustments, the kind people make when certainty starts slipping. I didn't look at him. I kept my attention on the table, on the grain of the wood, on the steady pressure of my palms. Confrontation would have been easier, louder, more satisfying in the short term. It also would have been useless, so I didn't confront her. I documented. Every time I found something that didn't line up, I wrote it down without commentary. No conclusions, no speculation, just facts, dates, amounts, entity names, signatures. I built a timeline that could stand on its own, even if my name were stripped off the cover. At work, I did the same thing. Different context, same discipline. When a shipment didn't match a manifest, you didn't accuse the vendor. You verified the count. When a contract didn't match the deliverables, you didn't argue intent. You checked the clause. The habit followed me home. My apartment became a quiet workspace. No dramatic late nights, no coffee-fueled panic. I set aside an hour after dinner and treated it like any other responsibility. Phone on silent. Laptop open. Files arranged in a clean hierarchy that made sense to someone other than me. Victoria, meanwhile, grew comfortable again. She assumed my silence meant I'd backed off. People like her mistake quiet for surrender. She resumed speaking to me in that familiar tone. Pleasant, managerial, faintly condescending. She talked about upcoming renovations, about market conditions, about how exhausting it was to carry everyone. I let her talk. The more she talked, the more she revealed what she thought was safe to reveal. Names slipped out, timelines overlapped. Just enough detail to fill in gaps she didn't realize were there. At one point, she mentioned a property I hadn't asked about yet. I made a note. Daniel became more visible too. Emails copied. Decisions framed as joint. His language was always careful, always supportive, always just vague enough to avoid responsibility. He positioned himself as a helper, not a driver. I noted that as well. One evening, while cross-referencing a transfer labeled administrative adjustment, I noticed something that made me sit back in my chair. The same amount had moved 3 times in 6 weeks. Different labels, same destination. A shell that existed solely to pass money through. That's when I stopped treating this as a collection of anomalies and started treating it as a system. Systems don't require intent to be proven. They require consistency. I reorganized my notes. I stopped grouping by asset and started grouping by behavior. Transfers without documentation, fees without services, sales without exits. Each category filled itself faster than I expected. I didn't rush to fill in motive. Motive is the least reliable part of any explanation. People lie about why they do things. Numbers don't lie about what they do. The judge shifted in her seat, adjusting her glasses. Victoria's leg bounced once beneath the table before she stilled it. Daniel leaned forward, whispering something urgent this time. I didn't need to hear it. At home, I kept my process boring on purpose. No dramatic revelations, no emotional reactions. If something didn't fit, I set it aside until I could verify it twice. If I couldn't verify it, it didn't make the file. That discipline mattered. The temptation to connect dots prematurely is strong when the picture starts to form. I resisted it. In my world, assumptions get people hurt. Precision keeps them safe. I consulted another professional, not for advice, for calibration. I described patterns without names, without family context, without emotion. Just structures, just flows. He frowned at the right places. Who's signing off on these, he asked. I told him. He didn't ask why. He asked how often. That was the question that confirmed it. As the weeks passed, Victoria's behavior shifted again. She became more attentive, more responsive. Documents arrived faster, though never complete. She praised my work, asked about my schedule, suggested we have lunch like old times. It would have been almost flattering if it weren't so transparent. I declined the lunches, accepted the documents, added them to the file. Daniel tried a different approach. He framed my questions as stress-induced, suggested I was taking on too much, mentioned how hard military life could be, how it changed people. I told him I was doing fine. He didn't like that answer. At one point, an email arrived that wasn't meant for me, a reply. All mistake, brief, technical, confirming a transfer window. It was gone a minute later, recalled, but not before I'd saved a copy. I didn't respond. I added it to the file. That was when I stopped pretending this could resolve quietly within the family. Not because of the amount involved, but because of the intent to keep it hidden. Families argue, they disagree, they even mismanage money. They don't usually build systems to avoid scrutiny unless scrutiny is dangerous. I scheduled another consultation this time with someone who understood both financial structures and consequences. I didn't ask if what I had was illegal. I asked what thresholds mattered. He didn't hesitate. Pattern, he said. Jurisdiction. Misrepresentation. I checked all 3 boxes without speaking. Back in the courtroom, the judge looked down at the letter again, her expression thoughtful now, rather than curious. Victoria's attorney shifted his papers, aligning them into a neat stack that suggested preparation without confidence. I sat still. Documenting everything had taken time. It had taken restraint. It had taken a willingness to let people underestimate me while I worked. That part hadn't been difficult. I'd been underestimated my entire life. What surprised me was how calm I felt once the file was complete. Not relieved, not vindicated, ready. I hadn't confronted my sister because confrontation would have allowed her to argue. I hadn't argued because arguments are distractions. Documentation isn't. The file existed now independent of me. It didn't care about family history or tone of voice. It told a story with or without my participation. Victoria had built her authority on control. I had built mine on record. And records don't blink when someone tries to intimidate them. My phone vibrated once on the table. Not a call, a calendar alert. Clearance review, follow-up documents due. I silenced it and kept my hands where they were. Pressure shows up in small ways first. You learn to recognize it before it decides how loud to be. Doing things the right way always costs more than people expect. It costs time. It costs sleep. It costs the option of pretending you didn't notice something when noticing would be inconvenient. I'd chosen that cost the moment I stopped asking Victoria questions and started building a record. The first price was distance. Not just from my sister, but from the comfortable fiction that family would smooth this over if I just explained myself better. I didn't explain. I didn't defend. I kept my language precise and my requests formal. That alone changed how people treated me. Victoria noticed it immediately. Her messages shifted from managerial to personal. She asked how I was holding up, told me she worried about me, mentioned how stressful my job must be. It was concern with an edge care framed as correction. I replied politely, briefly, with dates and document numbers. Daniel tried a softer approach. He called late one evening, his voice lower than usual, like we were sharing something confidential. "You know this could affect you too," he said. "Clearances are sensitive. They don't like complications." I told him accuracy wasn't a complication. He sighed, the sound people make when they think you're being unreasonable on purpose. "You don't have to prove anything," he said. "Families handle things internally." I told him the trust had disclosure provisions for a reason. Silence followed. Not thoughtful silence, the kind that weighs options. That was the second cost risk. Not the dramatic kind, but the professional kind. The quiet understanding that if this went sideways, it wouldn't be a family argument anymore. It would touch my record, my career, my credibility. People who don't live inside systems underestimate how unforgiving they can be. I didn't panic. Panic invites shortcuts. I did what I always do when the ground feels unstable. I checked my footing. I spoke to my commanding officer, not in detail, not with accusations. I told him I was involved in a private legal matter related to inherited assets and that I was handling it through proper channels. I asked if there were any reporting requirements I needed to be aware of. He listened, asked 2 questions, gave me clear guidance. "Keep it documented," he said, "and don't freelance." I thanked him and followed exactly that advice. The third cost was internal, the kind no one sees. I slept less, not because I was anxious, but because my mind stayed active longer than usual. Patterns have a way of replaying themselves once you've learned to see them. I learned to shut that off deliberately. No late-night theorizing, no spirals. When the hour was up, the file closed. Victoria tested boundaries. She scheduled meetings without agendas. She forwarded emails that implied urgency without substance. She tried to pull me into conversations that weren't recorded. I declined those invitations, always politely, always in writing. Her frustration leaked through the cracks. Short replies, missed calls, a comment at a family event about how some people don't understand the damage they cause when they don't trust others. I didn't react. At work, nothing changed. That was the point. I showed up on time. I met deadlines. I passed inspections. Consistency is the strongest counter to suspicion. When everything else feels unstable, routine becomes evidence. One afternoon, a colleague asked if everything was okay. I told him it was. That was true. Being under pressure doesn't mean something is wrong. It means something matters. The fourth cost arrived quietly. A letter from the trust's attorney, carefully worded, suggesting mediation, not offering information, not acknowledging discrepancies, just proposing a conversation. I read it once, then again. Mediation is useful when there's disagreement about interpretation. It's less useful when there's disagreement about facts. I declined. In writing, with citations. That's when the tone changed. Victoria stopped calling. Daniel stopped pretending to smooth things over. Communication narrowed to legal channels. Messages became shorter, more defensive, more precise. They were preparing, so was I. I refined the file. I removed anything that relied on inference. I highlighted repetition. I created a separate index that mapped behavior across time, rather than by asset. Anyone could follow it without knowing the family context. That mattered. I didn't share the file with friends. I didn't vent. I didn't seek validation. Validation is tempting when the cost starts adding up. It also makes you sloppy. In the courtroom, the judge asked a procedural question. Victoria's attorney answered quickly, too quickly. Daniel leaned back, arms crossed now, a posture that signals resistance rather than confidence. I noticed Victoria's jaw tighten when the judge referenced disclosure obligations. Not accusation, just language. Language has weight when it's chosen carefully. The cost of doing this the right way wasn't just personal or professional, it was strategic. I had to move at the pace the process allowed, not the pace my frustration wanted. Every step had to be defensible, repeatable, and boring. That's the part people get wrong about discipline. They think it's about toughness. It's about restraint. I received one more call from Daniel a few days later. This time his tone was sharper. "You're making this bigger than it needs to be," he said. I told him size wasn't the issue. Accuracy was. He asked what I wanted. I told him I wanted the trust to operate according to its own rules. He laughed once, short and humorless. "Be careful," he said. "People don't forget this kind of thing." I thanked him for the warning and ended the call. That night I reviewed my notes one more time. Not for new information, for coherence. Everything aligned. Dates matched. Signatures repeated. Transfers looped exactly as they had before. The cost had been real. Time, sleep, relationships. A measure of comfort I hadn't realized I valued until it was gone. What I gained was clarity. I wasn't guessing anymore. I wasn't reacting. I wasn't hoping for understanding. I was operating inside a framework that didn't bend to pressure or tone. In the courtroom, the judge folded the letter and set it beside her notepad. The motion deliberate. Victoria watched her closely now. No smile, no pretense. I sat still, feeling the familiar steadiness that comes when you've done everything you can without cutting corners. Doing this the right way had narrowed my options. It had also narrowed theirs. And in systems like these, narrowing options is often the most decisive move you can make. The judge's eyes moved from the letter to the attorney's and back again, measuring something she hadn't voiced yet. That quiet assessment mirrored the shift that had already happened for me weeks earlier when the work crossed a line I hadn't drawn but recognized immediately. It stopped being a family matter the day the numbers refused to stay local. Up until then, everything I'd documented could have lived in a civil file. Mismanagement, breach of duty, arguments about authority and disclosure. Ugly but familiar. The kind of dispute families pay professionals to sanitize. Then I traced a transfer that didn't belong to the state it claimed to belong to. I hadn't been looking for geography. I'd been verifying timing. The mismatch jumped out because the filing referenced a jurisdiction that didn't align with the property's location or the entity's registration. I checked it twice, then a third time. Money had crossed state lines under a label that didn't match its purpose. That detail changed the temperature of the room I wasn't sitting in yet. I didn't call Victoria. I didn't call Daniel. I pulled the relevant statutes and read them without drama. Interstate movement, characterization of income, reporting thresholds. The language was dry and unforgiving, exactly the way I prefer it. I made a note in the file. Potential federal exposure, not an accusation, a marker. The next consultation was different. I didn't present hypotheticals. I presented structure. The attorney listened without interrupting, flipping through pages, asking me to pause so he could align one document with another. When he finished, he didn't offer reassurance. He didn't speculate. "This isn't something you want to handle internally," he said. "Not anymore." I asked him what the correct path looked like. "Submission," he replied. "Voluntary, clean, with counsel." I asked what happened to families who tried to keep things quiet at this stage. He didn't smile. They usually regret it. I left his office with a clear list of next steps and no illusions about what they meant. Submitting documentation meant losing control over the pace. It meant answering questions I hadn't written myself. It meant accepting that outcomes wouldn't be negotiated over dinner. I took a day before acting, not to hesitate, to prepare. I reviewed my file with fresh eyes, trimming anything that relied on context only I could provide. I added citations. I included a summary that explained patterns without emotion or speculation. I labeled exhibits in plain language. No cleverness, no commentary. When I submitted it, I did so through counsel the way the system expects. No phone calls, no side conversations, no attempts to frame the narrative. The documentation spoke for itself. The response wasn't immediate. It never is. Systems don't move faster because you're anxious. They move when they're ready. In the meantime, life continued. That was the strange part. I went to work, I ran briefings, I corrected a junior officer's spreadsheet and reminded him to double-check his assumptions. I cooked dinner, I slept. Victoria noticed the shift before she understood it. Her emails changed tone again, shorter, more pointed. She asked if I'd taken this somewhere else. She reminded me that outside involvement could escalate unnecessarily. I replied with one sentence, "I'm following the appropriate process." She didn't respond. Daniel tried once more. His message was clipped, stripped of the friendliness he'd used before. "This doesn't need to become what you're making it," he wrote. I read it, saved it, and didn't answer. The first formal contact arrived a week later. Professional, neutral, acknowledging receipt, requesting clarification on a limited set of items. No accusations, no conclusions. I provided what they asked for exactly as requested. Victoria called me that night. She didn't bother with pleasantries. "What did you do?" she demanded. I told her I submitted documentation related to the trust's administration. Her voice rose, just a little, enough to reveal panic she couldn't fully contain. "You went outside the family," she said. "Do you have any idea what that does?" I told her I did. She accused me of betrayal, of overreacting, of trying to punish her for choosing a different life. The words tumbled out faster than she could organize them. Anger has a way of loosening people's grip on precision. I let her speak until she ran out of momentum. Then I said, "The documentation stands on its own." She hung up. That was the last direct conversation we had. After that, everything filtered through intermediaries, attorneys, emails drafted in passive voice, requests framed as cooperation rather than obligation. The illusion of control shifted from her to the process itself. At work, I reported the involvement as required, not the details, the existence. Transparency matters more than explanation in those moments. My commanding officer acknowledged it and told me to keep him informed of any changes. I did. The questions from outside agencies came in measured waves: clarifications, confirmations, requests for originals. I answered them all without commentary. Facts don't need advocacy when they're arranged properly. Victoria's behavior grew erratic. Not outwardly, not in ways anyone else would notice, but I could see it in the timing of responses, in the defensiveness of language, in the sudden eagerness to provide documents she'd withheld for years. It was too late for that to matter. The system doesn't reward late cooperation, it records it. In the courtroom, the judge adjusted the stack of papers in front of her, aligning the edges with care. It was a small gesture, but it carried intention. She wasn't skimming anymore. She was structuring. Victoria's attorney leaned toward her and whispered urgently. She nodded once, then stared straight ahead, jaw set, eyes unfocused. I didn't look at her. When something stops being a family matter, it doesn't announce itself. There's no dramatic moment where everyone agrees the rules have changed. It happens quietly when behavior crosses thresholds that don't care about bloodlines. I hadn't escalated. I'd complied. That distinction mattered. By the time the judge looked up again, her attention had shifted from personalities to obligations, from stories to standards. The room felt different, less conversational, more procedural. I sat with my hands folded, posture unchanged, the same way I do when a briefing transitions into an inspection. At that point, it no longer mattered how Victoria felt about me or what she thought my motives were. Those questions had been replaced by others she couldn't answer with tone or authority. The file had left my hands and entered a system designed to outlast emotions. Family arguments end when someone backs down. This had moved into a space where backing down doesn't reset the board. It only gets recorded. I lowered my gaze as the judge asked for a brief clarification, the kind of small procedural question that sounds harmless until you realize it isn't. Victoria answered quickly, too quickly, like she wanted to fill the space before it filled itself. I kept my expression neutral. Looking calm is easy. Looking forgettable takes practice. Playing weak isn't about lying. It's about letting other people project what they want onto you while you don't interrupt them. Outside the courtroom, that posture had already done its work. Victoria's strategy shifted once she sensed the process tightening. She stopped stonewalling and started oversharing. Documents arrived with friendly notes. Calls came framed as check-ins. She talked about how exhausting it all was, how misunderstood she felt, how she just wanted this resolved. I accepted everything she sent. I responded politely. I asked fewer questions. She mistook that for progress. Daniel followed suit. His emails grew longer, packed with explanations no one had requested. He used phrases like industry standard and temporary measures, confident that complexity would blur accountability. It didn't. It sharpened it. I saved everything. At work, I stayed deliberately unremarkable. No late nights, no visible stress. I kept my routine boring enough that no one had reason to worry about me. The best camouflage is consistency. The questions from outside agencies continued measured and specific. Each answer I provided was factual, sourced, and restrained. I didn't editorialize. I didn't volunteer more than was asked. Precision builds trust faster than enthusiasm. Victoria began to sense she was behind without knowing how far. She invited me to lunch, public place, neutral territory, the kind of gesture that looks conciliatory from the outside and strategic from the inside. I agreed. Agreeing costs nothing when you control what you say. She arrived early, already seated, already smiling. She talked first, setting the tone, describing stress, hinting at how this whole thing had spiraled out of proportion. "You seem tired," she said, studying my face. I told her work had been busy. She nodded, sympathetic. "I worry about you. This can't be good for your career." I thanked her for her concern. She leaned in slightly. "We could make this easier. You don't have to carry everything." I asked her what she meant. She spoke carefully, then choosing words the way people do when they think they're offering a compromise. She suggested revisiting distributions, adjusting roles, bringing in a neutral advisor, one she already knew. I listened. I nodded. I asked practical questions. I let her believe she was steering the conversation. When she finished, I said I appreciated the offer and needed to think about it. She smiled, relieved. "Of course. Take your time." I left the lunch with nothing new agreed upon and 3 new statements on record. That's the thing about playing weak. People say more when they think you're listening instead of evaluating. Daniel escalated next. His tone hardened. He warned about reputational damage, about drawn-out processes, about how ugly things could get when they went public. He framed it as advice. I told him I was following counsel. He didn't like that phrase. Counsel is impersonal. It doesn't negotiate. At home, I kept my notes updated. I created a separate log for communications after submission dates, times, content. Patterns emerged quickly. Attempts to influence. Attempts to gather information. Attempts to test how much I knew. I answered none of them directly. The outside questions grew narrower, less exploratory, more confirmatory. That shift told me the file was being read the way it was meant to be read. Victoria's confidence eroded in small ways. She began repeating herself. She contradicted earlier statements without realizing it. Her emails grew shorter again, stripped of warmth, packed with urgency. In the courtroom, the judge asked for a brief recess to review a point of law. Victoria stood immediately, pacing near her attorney. Daniel whispered, gesturing toward me, his hand slicing the air in frustration. I remained seated. That contrast mattered more than any argument. Judges notice who reacts and who waits. When the hearing resumed, the questions focused on disclosure timelines and authority. Not motive, not intent. Authority, process, compliance. Victoria answered, then corrected herself. Then deferred to counsel. I watched the sequence with detached interest. It was familiar. The moment when a system forces people to speak inside boundaries they didn't write. Outside the courtroom, messages continued to arrive. Some friendly, some sharp, some trying to bait a response. I replied only when necessary, always with facts, always without emotion. One message from Daniel stood out. Short, direct. "You think you're protected," it read. "You're not." I didn't reply. Threats are admissions when preserved properly. I added it to the log. Playing weak requires discipline. The instinct to assert yourself is strong when people push. Resisting it feels counterintuitive. But strength isn't volume, it's position. I had position. Victoria made one final attempt to regain control. She sent a packet of documents late one night with a note saying she wanted full transparency going forward. The packet included things I'd already documented months earlier, presented as if they were new disclosures. I compared timestamps. Originals beat revisions every time. I acknowledged receipt. That acknowledgement changed the tone of the next hearing. The judge's questions became sharper, her patience thinner. The room felt smaller, less conversational, more procedural. Victoria noticed it. She adjusted her posture. She avoided my eyes. Daniel sat rigid, arms crossed. His earlier confidence replaced by calculation. I stayed quiet. Holding the truth doesn't require broadcasting it. It requires keeping it intact while others test its edges. The judge set her pen down and looked at the attorneys, then at the file. Not at me, not at Victoria, at the record. In that moment, the room wasn't waiting for anyone to speak. It was waiting for someone to stop pretending. I didn't need to help with that. Playing weak had bought time. It had invited mistakes. It had let people show their hands without forcing mine. And now the truth sat where it belonged, inside a process that didn't care who felt offended or threatened. It cared whether the facts held. They did. Victoria arrived that morning dressed for victory. The jacket was sharper than usual, the color chosen to stand out without looking aggressive. Daniel followed half a step behind her, carrying a slim briefcase like a prop he'd rehearsed with. They took their seats quickly, efficiently, as if the room belonged to them. Confidence does that to people. It makes movement economical. I came in quietly and sat where I'd been sitting all along. Same chair, same table, same folder in front of me. Nothing about my posture invited attention, and that was the point. Victoria glanced at me once and looked away. No smile this time. Just a quick assessment, like she was checking whether I'd changed overnight. I hadn't. Her attorney opened with assurance. He spoke about procedural boundaries, about how much time had already been spent on what he called a narrow family disagreement. He emphasized cooperation. He emphasized transparency. He emphasized how proactive his client had been in providing documentation. Victoria nodded at the right moments. I listened without reaction. When someone tells a story that depends on selective memory, the safest thing you can do is let them finish. The judge let him talk longer than she had in previous sessions. That surprised him. He mistook patience for agreement and leaned into it, layering explanations on top of each other. The narrative expanded, grew more detailed, more confident. That's when mistakes usually happen. He referenced a document that hadn't been submitted, not directly, just enough to imply it existed. He used language that suggested access he didn't have. The judge didn't interrupt. Victoria glanced at him, then back at the bench. Her foot tapped once, then stopped. Daniel leaned toward her and whispered something. She shook her head slightly, eyes forward. When it was my attorney's turn, he stood without flourish. He didn't argue the story point by point. He didn't challenge tone. He asked a single question about timing. The judge turned back to Victoria's attorney. "Counsel," she said, "when was that information provided?" There was a pause. "Not long. Long enough," he answered, confidently. "Incorrectly." The judge made a note. Victoria's shoulders tightened. I focused on the sound of my own breathing. Slow, even. The same cadence I use during inspections when the room is waiting for someone to slip. The hearing continued. Questions narrowed. The judge asked about authority, who signed what, when, and under what provision. Victoria answered herself this time. Her voice steady, her phrasing careful. She spoke like someone who had rehearsed the right answers, but not the follow-up questions. The judge asked one of those. Victoria hesitated. Just a fraction of a second. Enough to recalibrate. She answered again, this time deferring to counsel. The judge wrote something else down. Daniel's confidence drained visibly. His posture shifted from relaxed to guarded. arms crossed, jaw set. He stared at the table like it might offer guidance. I didn't look at either of them. Confidence in a hearing isn't about volume, it's about familiarity. Victoria had spent years running meetings, leading discussions, controlling outcomes. Courtrooms look similar from the outside. Tables, chairs, people taking notes. What she hadn't accounted for was the difference between managing a room and being evaluated by it. Her attorney attempted to regain momentum. He reframed the discussion around intent, around good faith, around how difficult it is to manage complex assets without misunderstandings. The judge listened, then asked a question that cut through all of it. Did you disclose these transfers as required under the trust's reporting provisions? Victoria answered yes. The judge asked how. Victoria described summaries. The judge asked for specifics. Victoria deferred again. That's when the room shifted. The judge's questions became methodical, sequential, each one built on the last, tightening the frame. Not accusatory, just precise. I watched Victoria realize in real time that the confidence she'd brought into the room wasn't portable. It didn't apply here. It couldn't override documentation or process. Daniel whispered again, more urgently now. Victoria raised a hand, slightly silencing him without looking. The judge asked about a date I recognized, a transfer that had been mislabeled, a movement across jurisdictions that no amount of reframing could simplify. Victoria answered, her voice steady but thinner now. She said it was temporary. The judge asked temporary for how long? Victoria didn't answer right away. Her attorney stepped in. The judge looked at him and waited. He answered. The answer conflicted with the earlier one. The judge's pen stopped moving. I didn't shift in my seat. I didn't react. Reaction would have suggested surprise. There was none. This hearing was the one Victoria believed she'd win because it was the one she thought was about authority, about who had the right to decide and who didn't. She hadn't realized it had become about obligations. The judge called for a short pause, not a recess, just a moment to review something. Victoria stood immediately, her chair scraping slightly against the floor. She paced 2 steps, stopped, then turned toward her attorney with an expression that asked questions without speaking. Daniel stood too, rubbing his hands together like friction might produce an idea. I remained seated. That contrast wasn't lost on anyone. When the judge returned her attention to the room, her tone had changed. Not harsher, clearer. She outlined what she needed next. Specific documents, specific explanations, specific timelines. Victoria nodded through all of it. So did her attorney. Daniel didn't move. I listened, absorbing the language, noting how the focus had shifted entirely away from me. That was exactly where it needed to be. I wasn't the subject of this hearing. The trust was. The administration, the record. Confidence can carry you a long way when the rules are flexible. It doesn't survive when the rules start asking questions. As the judge wrapped up that segment of the hearing, she glanced briefly in my direction, not for validation, for confirmation that the record she was referencing existed. I met her gaze for a moment, and then looked back down at the table. The hearing that Victoria had walked into expecting to control had become something else entirely. Not dramatic, not loud, structured. And structure has a way of revealing who prepared for it and who assumed they wouldn't need to. Victoria sat back down slowly, her earlier composure replaced by calculation. She wasn't smiling anymore. She wasn't dismissive. She was adjusting. In rooms like this, adjustments don't change outcomes. They only change how people experience them. I kept my hands folded, posture unchanged, as the judge made one final note before moving on. The confidence Victoria brought into that hearing hadn't disappeared. It had just stopped mattering. The judge asked for the file. Not the summary, not the exhibit list. The file. Her clerk passed it forward, and the weight of it landed on the bench with a soft thud that carried farther than anyone expected. Victoria's attorney opened his mouth as if to add context, then closed it again when the judge lifted a hand. "Let's stay with the record," the judge said. She slid the letter free from the folder and unfolded it carefully, like she didn't want to crease anything she might need later. The room didn't move. Even the ambient noise outside the courtroom seemed to thin out, as if the building itself was paying attention. She read the first page without expression, then the second. Her eyes moved slower now, not skimming, not searching, verifying. Victoria watched her closely, chin raised, posture controlled. Daniel sat forward, elbows on knees, his hands clasped together so tightly his knuckles had gone pale. The judge paused at the bottom of the page and glanced up, not at me, not at Victoria, but at the attorneys. "Counsel," she said, "this letter references submissions made through counsel on specific dates." My attorney nodded. "Yes, Your Honor." She looked back down and continued. "There's a moment in rooms like this when people realize the center of gravity has shifted. You can feel it before you can name it. The questions change, the air changes, even the way people breathe changes." The judge turned another page. She underlined something with her pen. Victoria's attorney leaned toward her and whispered urgently. She shook her head once, a small, sharp movement that meant stop. The judge reached the section that outlined the pattern. Not accusations, not adjectives. Dates, amounts, jurisdictions. The part of the story that doesn't care who's telling it. She read that part twice. Then she smiled. It wasn't broad, it wasn't amused. It was the expression people get when a puzzle clicks into place and the solution explains more than they expected. "Oh," she said quietly, "this is good." The words landed without drama, but the effect was immediate. Daniel's shoulders sagged as if he'd been holding them up by force. Victoria's eyes flicked to him and then back to the bench, searching for something to anchor to. The judge continued reading now, with a rhythm that suggested she knew where she was going. She didn't rush, she didn't linger. She marked a line, flipped a page, and made a note. "Counsel," she said again, "this outlines a disclosure obligation that appears not to have been met." Victoria's attorney stood halfway, then sat back down. "Your Honor, if I may." In a moment, the judge replied, "I'm still reading." She finished the letter and set it down beside her notepad, aligning it carefully with the edge of the bench. That small act of order mattered. It meant she was done absorbing and ready to apply. She looked up. "Ms. Cole," she said, addressing Victoria directly, "are you disputing the accuracy of the records referenced here?" Victoria opened her mouth, then closed it. She glanced at her attorney, who nodded quickly, encouraging her to answer. "No," Victoria said. "But thank you," the judge said, cutting her off without raising her voice. "That's sufficient." Daniel shifted his chair, scraping slightly as he leaned back. He rubbed his hands together again, a nervous habit he'd never quite managed to break. The judge turned to the attorneys. "The court has concerns," she said, "not about intent, but about compliance. The structure described here is detailed, consistent, and corroborated by independent records." She tapped the letter once with her pen. "This is not a family disagreement. This is an administrative issue with legal implications." Victoria's attorney stood fully now. "Your Honor, we would request time to respond to." "You'll have it," the judge said, "but not to redefine the issue." She outlined next steps, not vague instructions, specific actions, documents to be produced, accounts to be frozen pending review, restrictions placed not as punishment, but as safeguards. Victoria listened, her face composed but tight, like she was holding tension in her jaw to keep it from spilling. Daniel stared straight ahead. I kept my hands folded on the table. The judge's tone never rose. She didn't accuse, she didn't lecture. She simply applied the framework as written, the kind of application that leaves very little room for interpretation. When she finished, she looked briefly in my direction. "Ms. Cole," she said, "thank you for your cooperation and restraint in this matter." I nodded once, not gratitude. Acknowledgement. Victoria's attorney objected to one procedural point. The judge listened, considered it, and adjusted a deadline by 48 hours. That was it. No grandstanding, no concessions that mattered. As the clerk recorded the orders, the room exhaled. Not relief, recognition. Victoria leaned toward Daniel and whispered something I couldn't hear. His response was a slight shake of the head, the kind that means the options you're discussing don't exist anymore. The judge gathered the papers into a neat stack and handed them back to the clerk. "We'll reconvene as scheduled," she said. "In the meantime, the court expects full compliance." She stood, everyone stood. As she exited the courtroom, noise returned in cautious increments. Chairs shifted, papers rustled. People spoke in low voices, choosing words carefully. Victoria remained seated for a moment longer than necessary. When she stood, her movements were slower, less certain. She avoided looking at me as she passed. Daniel followed, his earlier posture gone, replaced by something guarded and brittle. My attorney leaned toward me. "You did exactly what you were supposed to do," he said. I nodded. Outside the courtroom, the hallway felt brighter, louder, more ordinary than it had an hour earlier. People moved past us with no idea what had just shifted inside that room. Victoria's attorney caught up to her a few steps ahead. Their conversation was urgent, clipped, full of legal language meant to rebuild control. I didn't listen. I gathered my things and walked at an unhurried pace toward the exit. The envelope was back in the folder back under my arm, exactly where it had been when I arrived. The difference wasn't in what I carried. It was in what the room now carried with it: orders, records, obligations that didn't dissolve when people left the building. The judge hadn't laughed. She hadn't celebrated. She had smiled briefly at the moment the record made sense. That was enough. By the time I stepped outside into the afternoon light, the process was no longer abstract. It had shape now: timelines, boundaries, consequences that didn't depend on anyone's approval. I didn't feel triumphant, I felt aligned. And in systems that run on alignment rather than emotion, that feeling tends to last. The sidewalk outside the courthouse was warm, the kind of afternoon heat that makes people impatient for air-conditioned cars and quick exits. I stood there for a moment anyway, letting the noise settle into something ordinary. Traffic, footsteps, a siren a few blocks away. Life doing what it does regardless of who just lost control inside a courtroom. Victoria didn't come out right away. Neither did Daniel. I didn't wait to see them. Waiting would have implied interest. I had none. The next weeks unfolded the way processes do, methodically and without drama. Orders were carried out, accounts were restricted. Requests arrived with deadlines attached, and deadlines were met. When documentation is clean, the system doesn't argue with it. It moves. I kept working. That part surprised some people, though it shouldn't have. I showed up on time. I ran meetings. I signed off on deliverables that were actually delivered. When someone asked how things were going, I said fine and meant it. The trust was no longer a conversation. It was a file. Victoria tried once to reframe things. She sent a message through counsel suggesting a practical resolution, not an apology, not an acknowledgement, a proposal that assumed proximity would soften outcomes. It didn't. I declined without commentary. The terms were already set. Adjusting them would have required someone else's consent, and that someone didn't negotiate by tone. Daniel stopped reaching out altogether. His name still appeared in places it hadn't before, but now those appearances were contextualized. Timelines have a way of doing that. Once you see the sequence, the meaning becomes obvious. Family gatherings became simpler, smaller. Some invitations stopped arriving. Others came with a new kind of caution attached. I didn't take any of it personally. Alignment does that to social circles. When you stop playing along, people don't always know where to place you. That was fine. I never asked the court for her money, not once. I asked for compliance, for records, for adherence to the structure that already existed. The outcome followed from that. When distributions resumed under oversight, my portion arrived exactly as outlined. No bonuses, no adjustments, no quiet apologies attached. I accepted it and moved on. The quiet part came later, after the noise of activity had died down and what remained was just habit. I noticed how much space had opened up where tension used to live. Not relief, space. Room to think without running calculations in the background. I put that space to work. A colleague mentioned a program for military families dealing with financial stress. Not a scandal, not fraud, just confusion, misinformation, a lack of structure. I attended one of the sessions out of curiosity and recognized the same patterns I'd seen before, minus the malice. People don't need heroes, they need clarity. I volunteered to help with documentation, budget breakdowns, plain language explanations. The kind of work that doesn't make headlines but changes outcomes quietly. It felt familiar, useful, grounded. When someone asked why I was doing it, I said because it mattered. That was the truth. Victoria's name surfaced occasionally in updates, not gossip, administrative notices, changes in representation, requests for extensions that weren't granted. The system treated her the same way it treats everyone else, with indifference to status and patience for process. I didn't follow it closely. Following would have implied investment. I didn't need that to feel settled. One afternoon, a check-in email arrived confirming the last compliance item had been closed. No congratulations, no commentary, just confirmation. I archived it. The trust continued to exist now, constrained by the rules that had always applied to it. The difference was that someone was actually enforcing them. That wasn't revenge, it was maintenance. The word revenge gets used loosely. People imagine shouting, exposure, public collapse. What I experienced was quieter than that, more structural, the kind that rearranges reality without raising its voice. I never touched her money. I didn't need to. What I touched was the framework she thought only she understood. I read it, I respected it. I let it do what it was designed to do when someone stopped interfering with it. There's a difference between taking something and reclaiming alignment. One creates noise, the other creates stability. I chose stability. Months later, I ran into someone who knew both of us. They asked how things had turned out, lowering their voice like they were asking about a scandal. It resolved, I said. They waited for more. There wasn't any. The satisfaction people expect at the end of stories like this never arrived for me, and I didn't miss it. What arrived instead was a steady sense that I no longer had to prove anything. Not competence, not restraint, not worth. The judge's smile stayed with me not because it felt like validation, but because it marked the moment when the record spoke clearly enough to be heard. That's the only kind of smile that matters in rooms like that. I kept my routines. Morning workouts, clean inbox, evenings without background stress. When something needed attention, I gave it attention. When it didn't, I let it be. That's what winning looks like when you don't confuse volume with impact. I didn't rebuild anything from ashes, nothing burned. I adjusted course and kept moving. The life I wanted didn't require anyone else's loss to feel complete. Victoria once told me I'd never touch her money again. She was right. I built my own structure. One that doesn't depend on leverage or silence or control. One that works because it's meant to. And when things work the way they're meant to, there's very little left to argue about. 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 Little left to